Hello, everyone, and welcome. We are delighted that you're joining us today. Thank you for attending SCOTUS Revisits Abortion, Legal Strategies in Dobbs Oral Argument. My name is Rachel Rebouché. I am the Interim Dean and a Professor of Law at Temple Law School in Philadelphia. The Petrie-Flom Center of Health Law Policy, Biotechnology, and Bioethics at Harvard Law School, along with the Radcliffe Institute for Advanced Study, is delighted to bring you this event. So before we get to the discussion, just a few housekeeping items. We welcome audience questions for our speakers, so please submit your questions throughout the entire event. We will be pulling those questions to pose to panelists. You may be asking yourself, how do I submit questions? The best way to do that is to use the Zoom Q&A feature, which if you scroll towards the bottom of your Zoom window, you'll see a little button marked Q&A. Just type your question there. I'll be checking it frequently. You're also very welcome to join the conversation or submit questions on Twitter using hashtag Dobbs. Again, that's hashtag Dobbs. If you do submit a question there, Petrie-Flom staff will be monitoring it and will pull it to the Zoom Q&A feature. Ways you should not try to submit questions: the raise your hand feature on Zoom. We will not be checking that feature. We've also turned off the chat function so our panelists can focus on what's going on. So that's not going to be a venue for you to submit questions. If you're interested in this event and interested in other health policy, bioethics, biotechnology topics, we strongly encourage you to sign up for the Petrie-Flom Center newsletter, to read their blog, The Bill of Health, which features some really cutting-edge commentary by legal scholars. And I want to say personally a thank you to Glenn Cohen, professor at Harvard Law School and director of the center, for his support of this event. So with that, let's get started. I'm going to provide a very brief introduction in alphabetical order of our panelists. They're each going to take about 5 or so minutes to talk about their main takeaways from the Dobbs argument last week. And then we're going to jump into a Q&A. So conversational and conversational and I think what will be a very rich discussion. So in alphabetical order, first we have Catherine Glenn Foster, who is President and CEO of Americans United for Life. Sherif Girgis, Associate Professor of Law at Notre Dame Law School. Michelle Proctor-Goodwin, Chancellor's Professor at the University of California, Irvine, and Founding Director of the Center for Biotechnology and Global Health Policy. And finally, Mary Ziegler, the Stearns Weaver Miller Professor at Florida State University College of Law, and a visiting professor in spring 2022 at Harvard Law School. So with that, Catherine, kick us off.
Thank you. It's a real pleasure to join you all on this panel today to discuss what I believe may have been the most open and honest Supreme Court oral argument on abortion ever held. It involved ultimate questions, not only about the overturn of Roe, but also the role of religion, the validity of medical science, the reliance interests asserted by Casey, the history of abortion. Everything was fully aired, and all of the elephants in the room were called out and thrown on the table. This is the debate that we should have had in the Supreme Court decades ago, and I'm very grateful that we did hear it last week. Now, both sides and the Solicitor General, Elizabeth Prelogar, seemed committed to all or nothing positions. Mississippi, Scott Stewart, to overturning Roe, and Jackson Women's Health, Julie Reichelman, and the Solicitor General, to a fully robust Roe that harkened back to the pre-Casey era. As an advocate, I enjoyed hearing Justice Alito boxing Reichelman into admitting that they would accept no partial standard if Roe and Casey were overturned. Justice Thomas did the same thing for Scott Stewart, and I would note that Stewart did clerk for Thomas by opening with the question of what standard would replace Roe. And General Stewart replied that the rational basis standard would govern, that same standard that applies to all laws. So to both sides, the outcome in Dobbs is a zero-sum game. We'll see if a majority of the court agrees. The real history of abortion law, though, was thoroughly vetted, thanks to Justice Alito referencing the top historian of abortion, Dr. Joseph Della Penna of Villanova, whose just incredible 1,200-page work on abortion history, dispelling the myths of abortion history, has never been equaled. Mississippi detailed the truth about the danger of abortion at 15 weeks and the science that tells us that babies feel pain on abortion at that age. Despite Justice Sotomayor's protestations, the doctors who do that prenatal intrafetal surgery, they don't deny that infants in the womb feel pain. In fact, they use fetal anesthetic. The Chief Justice came out skeptical of the viability line of Casey. He rightly remarked, in my view, that as far as viability goes, I don't see what that viability has to do with the question of choice at all, rejecting the solicitor's contention that viability is, quote, both a logical and a biological justification that it marks the point in pregnancy when the fetus is capable of meaningful life. The Chief Justice cited to former Yale Dean John Hart Ely and saying that the United States argument was a complete syllogism. That's the definition of viability. It's not a reason that viability is a good line. Chief Justice Roberts pushed back strongly on the notion that women rely on abortion even at 12 weeks, 15 weeks, or later, especially since Roe essentially brooks no exception to that reliance interest. Markedly, the Chief Justice indicated that a 15-week ban is not a dramatic departure from viability. It is the standard that the vast majority of other countries have. The Chief Justice referred to the fact there that Roe makes the US extreme, in bad company with anti-humanitarian nations like China and Vietnam. I thought the question by Justice Sotomayor, how is your interest in prenatal life anything but a religious view? It kind of ripped the mask off the anti-religious animus behind the pro-abortion position. AUL itself is not a religious organization, and my friends at Secular Pro-Life, New Wave Feminists, and other non-religious pro-life organizations would take serious issue with this wrong-headed notion. The pro-abortion justices seemed on the defensive. Justice Breyer sounded downright desperate to retain Roe and Casey, based not on any constitutional defense of Roe or a policy-based defense of abortion, but solely really on stare decisis and the court's need to avoid so-called political controversies. Clearly, he was arguing to an audience of one, the Chief Justice. Justice Sotomayor just avoided the hard questions about fetal development and fetal pain, deflecting them every chance she got. Justice Kagan was not as engaged as an advocate for Roe. She appeared actually a little bit confused at one point when she asked Scott Stewart what the effect of the court's decision would be on future cases. And Scott appropriately told her that there wouldn't be future cases. Now, reporters keep asking us where the court is going, and I have to say, I don't know, but I do like where they're sitting right now. The fact that they are camped in this spot, thoroughly discussing the hardest questions about abortion, religion, medicine, legitimacy of the court, politics, even 14th Amendment personhood, it's all extremely encouraging. The pro-life movement has always said that the presuppositions of Roe would wither under a truly close examination, and it looks like our prediction may be coming true. For the sake of women's health, human life, and the integrity of the judiciary, I hope that the court finally puts an end to Roe. It's high time that we stopped talking about the court chipping away at Roe. We are well past that. Roe has been hacked to pieces over nearly 50 years as the Supreme Court has furiously backpedaled from the extreme abortion right that it created out of thin air in Roe. Roe is an Ozymandias, a derelict adrift, a ghost ship crewed by the memories of what it once was, or depending on what your cultural preference is there. It could be the Statue of Liberty, the head of the Statue of Liberty on the beach in Planet of the Apes, or the Monty Python sketch where the swordsman's been chopped to pieces and still keeps insisting it's only a flesh wound. I think it's clear that it's past time for the court to lay it to rest and return the most controversial political issue of our day to the states and to the people where it belongs.
Thank you. Next up, Sherif.
Thank you. I want to start by saying thanks so much for having me on this panel. I've been on a panel with some of the members, have profitably read all of the members, and really glad to do this. I'm also glad that we picked a slightly unusual topic that you did. So the topic, as I understand it, is talking about the legal strategies that were used at oral argument. And that connects to another issue that this case has raised for me in general. So we often talk about how much power judges have in a society that in a system that has judicial review and precedent. But I actually think this case highlights how much power lawyers can have over major policy questions when you combine judicial review and precedent with a kind of adversarial system and with a lot of the doctrines that usually go along with that, like the party presentation principle. So courts are mostly going to go by the arguments the parties raise, are going to be mostly hemmed in by those arguments, and so on. And I'll try to highlight in a few ways why that is. And I'm just going to go through 3 surprises for me from the oral argument. So the first surprise is one that was already touched on, which is that none of the parties seemed interested in a middle ground. This was already pretty much, the groundwork for that was laid in the briefs, but it was still striking to hear it out loud. I mean, several points you had counsel for the clinics or for the United States being pressed. So if we don't buy your main theory for why you should win, what about this backup? And the only time I can ever remember advocates doing this in an oral argument, they rejected the backup rather than taking it as a fallback. The Mississippi did something pretty similar. So even though in his brief, the Solicitor General for Mississippi laid out 2 off-ramps the court could take, ways to uphold the law without overturning Roe and Casey in full. In his opening, he did not mention them at all. When Justice Kagan asked him about them, he led not with an explanation of what they are, but with an explanation of what's wrong with them. So all of them were pretty maximalist, all of the lawyers. And one thing that highlights, I think, is the way that these kinds of cases might be a challenge to our usual conceptions of good advocacy. So we usually think zealous advocate means you focus on your client's interests above all, and you understand your client's interests really narrowly to mean winning in this case. But obviously both sides in the United States are thinking of this case as part of a broader social or political movement. And from that perspective, these 2 things could come apart. It could be that your client losing bigger is actually better from the perspective of the movement you also care about than if your client lost small. And there's a question, I mean, one thing these cases just force us to ask is this good advocacy? Is there, should we change our conception of zealous advocacy in these kinds of cases? Maybe there should be a division of labor where government actors, with the US on the one side, Mississippi on the other, can take into account broader considerations like their ongoing power to regulate in more extensive ways on Mississippi's side, or the US is concerned for abortion law more broadly than in this case. But it's one serious question to ask. And it's also a striking case of the general thing I started with, which is the way in which the choices that one random lawyer might make could have huge impact on abortion policy in the country for decades. I mean, I think it's clear that if the Solicitor General had not asked for full reversal, there's no way that someone like Justice Kavanaugh would have reached out to go for that. And so if another lawyer had been the one whose case got up to the court, we might have a very different abortion policy for the next several decades. Striking. So on the clinic side, one surprise from the clinics, I think, is that there was a kind of missed opportunity to refound Roe v. Wade. So it's widely thought on the left and the right that Roe itself, whatever you think of its conclusion, was very poorly reasoned. There was a kind of cottage industry of academic work over the last 50 years trying to find a better rationale. I think it's fair to say that a lot of it has converged on some kind of equal protection argument for abortion access, the idea that women's equal access to the marketplace and public life and employment and so on requires that they have some reasonable opportunity to get an abortion. And even though equality came up kind of 2 or 3 times, like as a tertiary answer to a question or a backup or something like that, almost entirely the argument was stare decisis. And it's easy to see why. That's the kind of argument that this court is going to be more likely to be receptive to. But once you're already thinking about the broader concerns of the movement, you might have thought that you want to take this opportunity also to give the dissenters, if it ends up being a dissent, or the majority or a concurring opinion, if you end up winning, some new rationale to found abortion rights on, or to found the argument on for another day. And we didn't see that. So what's the diagnosis of that? I don't know. I think one possibility, and this might also explain the choice to go maximalist on the side of the challengers to the law, is that they thought there's no other rationale that could justify viability being the line. And Chief Justice Roberts tried to touch on this at some point. If choice is the point, then you just need a fair opportunity, and you don't necessarily need 24 weeks unless you have a special case where you couldn't have learned of the pregnancy until then, or you didn't have reasonable access until then, in which case you might get an as-applied challenge. But that just pushes the question back. Why were the challengers so insistent on sticking to viability at all costs without even a backup plan? And you might think, well, they would have thought, if we give up on viability here, it's going to be a stepping stone to overturning Roe. And they had no reason to ask my advice. But if I were advising them, and I were advising them with a view to preserving some kind of residual abortion right, I would have actually thought the opposite. So I would have thought that if you took this opportunity to narrow the right a little bit, but founded on this idea that a woman gets a fair opportunity to choose, it might be more stable in the long run. So first of all, it would be a brand new rule. So the court would not be relying on Casey or Roe. So they'd be justifying this rule in their own voice. That makes it harder for them to overturn down the road, because then they'd be disagreeing not just with Roe and Casey, but with their own words in Dobbs. Second of all, this kind of fair opportunity to choose thing, unlike Casey and Roe, would not be pegged to potentially evolving judgments of fetal work. So Roe itself said, viability is the line because that's when the fetus counts enough morally to count enough constitutionally. That's an extremely implausible judgment in itself because it makes moral worth of the fetus depend on extrinsic factors like the state of technology. But if you just had this, look, one way or another, the 14th Amendment guarantees a fair opportunity to choose, then it wouldn't have been pegged to any particular kind of contestable judgment about moral worth or anything like that. And it might have been more stable in the long run. But for whatever reason, it wasn't the choice they made. Finally, in terms of surprises on Mississippi's side, the thing that most struck me about the oral argument is that both in his opening and in his conclusion and in one of his answers to, why does this case matter so much, the Solicitor General referred to the toll on human life taken by Roe and Casey, referring to the deaths of unborn children or fetuses. And the reason that's striking to me is obviously Casey and Roe say, look, states can reasonably take that idea into account. They can treat this as the taking of life. But it's odd to ask the court to recognize this as a taking of life in the course of figuring out what rule to apply, especially since he was clear he was not asking the court to hold that the unborn are 14th Amendment persons. So why was he making that choice? It's a kind of atmospheric thing, I guess. And my thought is that even if it's not technically legally relevant according to his arguments, as an atmospheric matter, it's helpful, but it's also, the more you credit the idea that it's at least permissible for a state to see this as the intentional taking of an innocent life, as lethal violence against the most vulnerable people in our community, the easier it is to see the intuitive response to a wide range of arguments for abortion access. Just to end on one example, if you say, look, equal protection of the laws and women's equal access to public life and political life and a wide range of choices requires access to abortion, the background thought will be, the more you hear his atmospheric point about this is a toll on innocent human life, the easier it'll be for someone to say, well, hold on, in what other scenario do we think that equal protection for one group requires withdrawing the protection of homicide laws from another group? So the impulse to try to find some other way to protect women's equal access to the market and to the public square will be stronger. It'll be easier to say, well, look, whatever equality requires, it doesn't require this particular means to improving women's access. And so a lot of the most difficult and wrenching parade of horribles for the state, a lot of the strongest affirmative arguments for abortion access would, I think, be undercut. The more you credited the idea that it's at least permissible in itself for the state to treat this as the taking of innocent life, that there's not an independent constitutional problem with that, some rebuttals to other arguments show up. So I had a lot more thoughts. I'm happy to talk about all of them in Q&A.
Thank you. Michelle.
Hey, it's a pleasure to be with you all. And I have to apologize to the audience for needing to get off the call early today, but it is important to have this conversation. So the framing here is about the way, the structure, the arguments that were laid out this past week in the Dobbs case. And what I'd like to do is something that's slightly different than the two prior presenters, which is to think about the ethnographic aspects, the empirical aspects left off the table that would have been or could have been part of this engagement. And I want to just take a slice of it because the other presenters are covering some of the other broader spaces. So Mississippi, just like Texas, provides no exceptions in instances of rape or incest. This, even for conservative positions, is really quite extreme. But I think the pathway to getting to where we are now has been long layered before now and paved outside of the abortion context. There's more that could be discussed in that realm, how ground was seeded in this domain. But where it really matters is that so much of that ground was in fact seeded with regard to race and the policing of Black women and Latina women's bodies during the 1980s and 90s. This is when the real kind of push towards personhood emerged in the criminalization of Black women and Latinx women for conduct during their pregnancies. Sadly, because the movement that considers itself grounded in reproductive rights really centered around abortion, it failed to really account for and to see that when prosecutors and police officers were leaning into prosecuting and pursuing Black and Latina women for not carrying their pregnancies in the way in which the state would deem appropriate, that was really framing a groundwork for the kind of personhood narratives that we see today. And what's interesting about the arguments is that you could go through the transcripts entirely and listen to the oral arguments, and what you won't find are the attorneys or the justices engaging on questions about, well, what happens when a child is raped by an uncle, a father, or brother? And this law provides no exceptions. Children are absolutely absent from this discussion, although purposefully, Mississippi and Texas have in fact drafted laws that provide no room for these exceptions. And so the failure all around for that to be engaged is really quite stunning. So what exactly does that mean with regard to capacities, interests, responsibility to engage on these particular issues? It exposes that liberals and conservatives may lack the sophistication and capacities to address these issues. We may also assume somehow that there is some deep understanding about the trauma and the harms that are caused by this, such that they don't need to be articulated either by those who are litigating these cases or by the justices that are hearing these cases. But I think that that would misstate and overstate. What's interesting in this case is that the failure to address this within the capacity of oral arguments and also from the justices in terms of questioning exposes a real disconnect between the lives of those who are most affected from the manner in which the states legislate and lawyers will litigate. Mississippi did not hold hearings inviting survivors or sexual assault survivors of incest or rape to testify. And what's interesting about this is that if you think about the work that Justice Blackmun did in Roe, and Roe is criticized quite often for being a case that's not just about women, it's really about decriminalizing doctors being able to do their practice in a space and time in which the majority of those doctors who are doing this kind of care happen to be men. So one cynical way of thinking about Roe is that it's a case about protecting male doctors. But I think that that misses some very important points that are made by Justice Blackmun in Roe v. Wade, and that he really elevates and centers the lives of women and also does the kind of archival work that's important in reaching back through history to understand when and how and if abortion had been criminalized previously. But to my point, what Justice Blackmun also does is he really unpacks in reality what happens to individuals who are forced by the state to continue pregnancies that they do not want. And one of the things that is really important is that he underscores that this is not just a physical threat of health, but also a psychological threat of health. And it also infringes on education and career. Now, what's interesting is some of that layer of argumentation was made this past week. And also Justice Amy Coney Barrett seemed to suggest that there's really not a big deal with having to carry a pregnancy all the way to term, being forced to do that by the state, because after all, adoption happens to be available. Now, of course, that there are very significant blind spots with regard to that and a level of coercion that we just don't see in any other way within the United States. I know recently some people said, well, that's just like vaccination. We'll leave that to the side. Let me just say that there is no draft. The United States has gotten rid of the draft. We force no one to endure the kinds of things that the court would seem to suggest that individuals should. Now, as I bring my comments to close, here are a couple of things that I think that we might learn had there actually been some engagement along this path, which the justices didn't engage in, and neither did those who were litigating the case. That would be that only 2% of teenage girls, and this is rape and incest aside, but only 2% of girls who become pregnant as teenagers actually graduate from college by the age of 30. To suggest that somehow pregnancy during teen years doesn't affect someone is really quite ludicrous. Barely 40% actually even graduate from high school. So we know that life chances are really significantly upended. And had there been some line of questioning there, then perhaps some of this would have come up to the fore. The other thing that I think has really been lacking along the arc of the jurisprudence and in cases in this domain, brought up by Breyer for sure in Whole Woman's Health, but we don't really take as seriously as we should, and the justices haven't really paid attention to the fact that a person is 14 times more likely to die by carrying a pregnancy to term than by terminating it, and that an abortion is the safest procedure that one could possibly have. So that when these laws are framed as protecting the interest and health of women, then there's really just simply subterfuge that's really far more illusory than real. And finally, let's just be clear about who's affected in Mississippi. And that too was not brought home as much as it could be. That is to say that in Mississippi, there's only one abortion clinic that remains. The majority of the people that they see happen to be poor women and Black women. And when we look at the arc of history in the state of Mississippi, the significant disregard for the lives of Black people, which I don't think we have to argue that point, history just simply reveals that in the state of Mississippi. And the fact that Black women are 3.5 times more likely nationally to die by carrying pregnancies to term than their white counterparts, and how that quadruples in certain Mississippi counties, then we're really talking about issues that in any other context, we might actually call something like a death sentence that is being imposed. And that's not hyperbole. Those are the data points that we have. Those are the data points that our government puts together. Those are actually the data points that are produced by the state of Mississippi alone. So with that, what I'm going to do is turn it over to then Mary Ziegler, I think, who comes up next. And thank you so much for having me.
Thank you, Michelle. Mary.
So I was going to talk a little bit about why I think the advocates took maximalist positions, and I think which raise interesting questions about what might come next. So we haven't talked much about what we think is going to happen, and we'll talk more about that later. What I think is going to happen based on the argument is that the court is going to overrule Roe in this case versus doing so in a kind of series of steps, which would have been my thought going into the case. So the interesting question is why both parties wanted to kind of go all or nothing on that proposition to give the court fewer options. If, for example, Justices Barrett or Kavanaugh feel attracted to what seemed to be just Chief Justice Roberts' attempt to offer some kind of middle ground. I'm hesitant to use that term because it would be a sea change in abortion jurisprudence, but something short of overruling Roe, like getting rid of viability as the dividing line, but not going all the way to saying that there is no right to choose abortion. I was struck throughout the argument by how essentially Chief Justice Roberts kept throwing that out and finding no takers, no interest, until at some point more than halfway through the argument when Justice Barrett seemed inclined to take that point up at least a little bit. So in part, you may assume that the advocates had read the room better than I had, and that they saw that the justices may be leaning toward entirely eliminating Roe. But I think, as all of us have said, this was more, in both cases, I think, a strategy designed not to serve just the aims of specific clients, but the aims of movements. So I think from the standpoint of Mississippi and the broader anti-abortion or right to life movement, the reasons for shooting for a kind of clear overruling are fairly straightforward, insofar as more ambiguous rulings, right, that purport to preserve Roe or an abortion right while effectively gutting that right may be good in the short term from the standpoint of eliminating even the possibility of political fallout, but bad in the long term. I think some in both movements read Planned Parenthood versus Casey as just that kind of ruling, a case that could have been a gutting of abortion rights, that could have made the undue burden test the equivalent of rational basis or something that opens the door to almost any regulation, but that then was sort of revived by a court later on in Holman's Health versus Hellerstedt. So the idea is that absent some kind of clear repudiation of Roe, there could be a sort of zombie abortion right hanging around for a more liberal court to revive in future years. And we've sort of seen that movie before, so that was a possibility. It's maybe harder at first blush to understand why abortion rights or pro-choice pro-choice attorneys would take a similar strategic stance. I think the calculation there has to do with political backlash and the thought that a kind of Roberts-style putative compromise would be hard for most voters to understand. It would be hard for the media to understand and explain, and that might kind of manage or minimize any kind of political fallout, because after all, this case is likely to come out in an election year shortly before another election year. And the thought was that the clearer repudiation you had, the larger a political reaction you would get. And so I think those were the kinds of considerations that were animating both sides here. I think relatedly, for people on the abortion rights side, there was a belief that the elimination of viability was such a substantial change to abortion rights that calling it a middle ground or calling it the preservation of abortion rights was intellectually dishonest in a way that the movement didn't want to pursue. I think both of those are interesting calculations because they're predicated, I think, in part on a political world that we may no longer inhabit. It's interesting to kind of think through what the politics of Roe backlash would look like in a world that's as intensely polarized as our own, certainly in which some states are functionally politically uncompetitive, regardless of what happens in the Supreme Court in this or any other case, and the extent to which even national races are affected by polarization in difficult ways. So certainly in 1992, when Casey was being argued, the politics of backlash made sense in ways, transparent ways that I'm not sure is the case anymore. So it'll be interesting to see if this calculation, this sort of trade-off of a clear loss for a potential clear political win, will carry through. I think it's hard for me, at any rate, looking at this as a historian, to predict what the reaction will likely be. I thought I've seen people on both sides emphasize the liberal justices' lack of a defense of a sort of better foundation, if you will, for abortion rights than the privacy or autonomy grounded one that we saw articulated in Roe and Casey. And I think that was intended to be, at least among the liberal justices, their sort of best bet in their view as to how to reach their colleagues whom they probably correctly believed did not believe there was a right to choose abortion, whether grounded in equality or autonomy in the Constitution. And they believed, it seemed, that the best way to do that was to focus on institutional concerns and image concerns and the threat of possible damage to the court's institutional legitimacy. And that may be potentially easier to predict, if only because there's already some sense that institutional legitimacy, at least in short-term ways, is anchored to the court's people's perception that the court is or is not partisan. There are ways, of course, that a court could overrule Roe that would not be partisan. I don't think the justices are, if they overrule Roe, as I anticipate they will view themselves as performing a partisan act. I think they'll be acting in line with long-standing interpretive preferences. I think the problem for them, of course, is that the Supreme Court has become a centerpiece of partisan elections. Supreme Court nominees are a reason many turn out to vote. And of course, as is often the case in the abortion context, the court is only one participant in a much broader and more complicated national dialogue, as Sherif mentioned, driven by attorneys, but certainly also driven by politicians, social movements, lobbyists, doctors, and a variety of other actors. And those actors, including folks who've put some of the current members of the court on the bench, have framed the court as political, particularly when it comes to Roe, in ways that may have difficult to anticipate consequences. So in watching what happens next, I'm curious to see if some of the calculations that I saw playing out in the oral argument prove to be correct when it comes to both how people conceive of the court and its legitimacy, and also how people conceive of Roe as an engine of political change, whether we're either thinking of the preservation or elimination of Roe. And I'll stop there so we have time for questions. I also apologize because I also have to get off the call early. So with that, telling you I'm not going to be here anymore, I'll now turn it over to Rachel for questions.
Well, so I want to use the time that we have with Michelle and Mary. And so I'm going to ask a question, and I'd like to hear from all of our panelists, and then I'm going to have a quick follow-up question that's from from one of our audience members, please use the Q&A function. So you've all touched on the point of consensus is that Roe does not have to be overturned to be gutted. And Roe does not have to be overturned to effectively mean severe problems of access to services for lots of people in this country. So if you're thinking about either way, a different viability, a different standard other than viability, or overturning Roe, what do movements that are supportive of abortion and movements that are not supportive of abortion, what are their priorities going forward? What messages are they trying to send? I think we heard Michelle powerfully speak to some of the messages that were missing, some of the conversation that the court did not have last Wednesday. But how does each side of this debate, where does it focus its energies, January to June and then after?
So, you know, as you asked the question about movements, so if we're thinking about, you know, who comprise the movements, right? Sort of lawyers movement, activist movements, the movements of communities that would seek to ban abortion, the communities that would seek to advance reproductive health rights and justice. I think one consideration is that in the backlash of Texas, the Texas law, there are already people who are leaving the state of Texas, going to California, going to Colorado, going to other states. I think that there's going to be some attention on, you know, how is there support means to create support in order to help people be able to do that. I think legislatively, there are going to be concerns from those who would like to see abortions not take place anymore, to legislate in that space about people leaving and going to other states to obtain abortions. And I think equally, there's going to be some movement attention towards how to create the essentially sanctuary states for abortion, sanctuary cities. I think that that's going to be on the horizon within this front. I think as well, some things that may be overlooked is really spending time on the empirical front about what does viability actually mean. That there's not a consistent point of view on that. That is to say that there are some doctors that say viability is just simply when the baby is born, that unless you're going to perform a C-section and forcibly remove a fetus from a person's body, then that fetus is not viable. It's not viable until we could see that it is actually viable. How do we see that it's actually viable? Is the state going to say, well, I mean, so I think that there's going to be some contestation and debate about that. And then finally, I think on the horizon is looking at the other states that would be triggered by what the Supreme Court does in Texas with the Texas case, and also by the Mississippi case. You know, so as we look at it in an isolated way, right, this is just Mississippi, but it's not just Mississippi. There are other states that have enacted pretty prohibitive abortion bans that, depending upon how the Supreme Court rules in the SB8 case or in the Mississippi case, will dramatically change the face of abortion rights in the United States.
I mean, things I'm watching for. So I imagine, and I've talked to some people, you know, because I'm a historian, I actually talk to people on both sides of this sometimes. So I've heard what I've been hearing. Obviously, on the abortion rights side, I think there's going to be a real focus on access in a way that really, I would say, really hasn't been true in some ways. I think there's been a sort of focus on rights at the expense of access. And I think we're about, obviously, to see a reversal of that in ways Michelle described. The sort of idea of sanctuary states, I think, is a real possibility. I think that's going to raise questions for folks in states with anti-abortion or right to life majorities about what to do about that, right? So do you, for example, Mark Lee Dixon, who's the sort of, I guess, patron saint of the sanctuary city for the unborn movement in Texas, has told me there are already conversations afoot about making it criminal to perform an abortion on someone who's crossed state lines from Texas to get one done. But then, of course, that's not really, I mean, California is not sending doctors to Texas to face prosecution. So then that raises the question of, well, what comes next? So if you're Texas, do you do you prosecute people for self-managed abortions? Do you prosecute people for crossing state lines to get abortions? Do you prosecute people for aiding and abetting people for crossing state lines to get abortions? I think the sort of tricky part of, if states that are more pro-choice are going to encourage people to come from out of state or are going to send abortion medication from out of state, how does the Right to Life movement respond? In particular, when there are two prominent stated positions that groups like AUL have made abundantly clear, which is we're not going to punish women, but we want to have enforceable abortion laws. And I think there's going to be a tricky navigation in a post-Roe America of what that actually looks like, especially if blue states like California are saying, no, our borders are open, come on in, or we're sending you abortion medication. And frankly, I don't know what the answer to that is. And I imagine that from a social movement standpoint, that's probably going to be contested. I imagine that's probably going to be contested on the pro-choice side too, in terms of doctors, how willing doctors are to potentially face legal exposure to perform abortions on folks from out of state, or, abortion funds and others who might be aiding people and exposing themselves legally. So I think in all of these contexts, I'm looking to see how those debates play out. I don't purport to know the answer, and I imagine that there's not going to be one answer. I imagine there's going to be several answers. Those strike me as complicated movement questions. I think the positions people take now will be under some pretty intense pressure, because we're going to face significant changes to what this landscape looks like if the court does in fact overrule Roe in June, as I expect.
Sherif, Catherine?
Yeah, just picking up on the last point that Mary made about kind of contestation within the movement, that on the pro-life side, for example, there's been for almost 50 years, this very concrete, determinate, specific goal that all the different groups can organize around. And once that's gone, and if it is gone, and then there's this possibility of actually legislating in a really broad-ranging way, there'll be a lot more choices about what to do and a lot more division about how to go about doing it. It's kind of like moving from an opposition party to a governing party, and all the choices and kind of fractures that are possible at that point. So I think there will be obviously the general pattern will be trying to go then to the state legislatures and making arguments for broader and broader abortion regulations. I think one good effect is that because those laws will not just be kind of symbolic or just challenges to Roe, they will actually have the possibility of taking effect. There will also be more kind of salutary pressure to join those regulations with serious provisions for the needs of women in difficult situations and for easier adoption and other kinds of goals that the pro-life movement says it wants to pair these abortion bans with, but has not had to spend a ton of time on, because the bans, at least pre-viability, were never going to take effect. So it can have a number of effects. It's not going to be a pure boost. It'll have some challenges that come along with it, but I think some good that will come of those challenges.
Yeah, I'm looking forward to the to the challenges ahead for when the court does overturn Roe. I believe that that a number of states have marked their positions, and so it's going to be it's really going to be up to advocates on both sides to go in and work with legislators and work with engaging the people and really return to that democratic process, as both Mary and Sherif have really highlighted here. And focusing on many of the points that Michelle has made as well. These are all key points as we look to engage the public and educate them on what exactly the law regarding abortion should look like in their states.
Great. There's a quick question that's directed towards Professor Goodwin, but it's for all panelists. Is there a viable 13th Amendment argument in favor of abortion, the state mandating women to give birth?
So I'll take that question, and then I will have my departure. I wish I could stay with you all. It's a great question, in that the 13th Amendment is part of the Reconstruction Amendments. It was the law that abolished slavery in the United States, slavery and involuntary servitude. We know that slavery was an enterprise in the United States that was supported through the federal government, through fugitive slave acts, and also supported at state levels and protected the property interest of private individuals, as well as later in its exception clause with regard to the state. It certainly does raise very significant 13th Amendment issues when the state coerces or forces a person to continue a pregnancy that a person does not want. What is the legitimizing factor for that? Other than there are some people in the state legislature who say that they want that to happen. In Mississippi, there's something glaring about that. That is to say that Mississippi is a notorious state for its race laws, its laws during slavery and also post-slavery, which most law students really aren't taught, but it's worth considering Holly Murray's book on race laws, which Thurgood Marshall called the Bible of the Civil Rights Movement. And one then could really get a sense of the texture in the way in which Mississippi was outrageously litigating in very racist ways against Black people. I mean, essentially stripping any kind of right to one's personhood. And so that serves as our backdrop here in this particular case. And it would seem to implicate the 13th Amendment when you have a predominantly white state legislature coercing predominantly Black women to continue something that is for the benefit of the legislatures and not something for the benefit of the women, because the women are articulating, this does not benefit me, I don't want it. And you have quite explicitly white male legislators saying that we believe that this is something that you should do. Now, that's a very simple way of articulating it. And I think that sometimes it's important to drill down to the basics of what these cases and what the legislation actually represents.
Thank you. Any other? Excellent. So I'm going to pull another question from the Q&A, and thank you to Professor Goodwin, and thank you to Professor Ziegler. Someone has asked, I'm curious what panelists would say, and I'm assuming this is a question posed if Roe is overturned, about a religious right to have an abortion. My religion says I can have an abortion. Would abortion access in that sense be constitutionally protected?
I'll take this because I now have to leave too. I mean, so I think I'm skeptical, right? Because the court certainly has been moving in the direction of expanding religious liberty, and we've seen that in a variety of cases in the past couple of terms. But we've also seen this term that some members of the court are skeptical about the sincerity of certain kinds of religious claims, for example, when raised in the context of the death penalty. And so I don't know. Obviously, we would have to see, but I would worry that the justices, or believe that the justices, may raise sincerity concerns about religious liberty arguments raised in favor of abortion rights, even if those are rooted in faith traditions, as they are in some contexts. So I think there's a sort of remains to be seen feeling to a lot of religious liberty jurisprudence in this context too, because it's rapidly changing. But I don't know if there would be a straightforward religious liberty claim that would work in a court that had just reversed Roe. And I apologize as well, because I now have to jump off, but I will leave you in the able hands of everyone else.
I guess on that point, I don't see any obstacle to saying that there is a substantial burden on somebody's religion. If, for example, they say, look, I have a religious obligation to meet the needs of my born children, and I've gotten pregnant, and that carrying this pregnancy to term and taking care of the child would create such a strain on my ability to provide for my other children that it's a violation of conscience, it's a violation of my religious duties to my family to carry the pregnancy to term. And I don't see any way for the doctrine to block that kind of argument. I don't think the doctrine should be such as to be able to block that kind of argument. But then the question becomes whether there's a compelling interest in enforcing the abortion regulation anyway. And I guess this brings me to the last point I had made in my opening, which is that thinking about different constitutional arguments for and against abortion access, it's very hard to bracket the question of what the court is thinking about whether there is a life, or what the moral and constitutional status of protecting that life might be. And if you think that, Roe and Casey themselves stand for the proposition that it is possible to think that an entity is not a 14th Amendment person, but that protecting its life is a compelling interest. Because under Roe and Casey both, that's true of the unborn child or fetus from viability until birth. So even from just kind of using that as a springboard, the court might say, look, there is a substantial burden. We're not questioning the sincerity of the claim. There's a real burden that triggers heightened scrutiny, but because the state can permissibly regard itself as having a compelling interest in protecting unborn life, it's that exemption is overridden.
Yeah, I would agree with that. And just turn to Mississippi's words in the case in Dobbs itself. According to the state, the Constitution places its trust in the people. On hard issue after hard issue, the people make this country work. Abortion is a hard issue. It demands the best from all of us, not a judgment by just a few of us. When an issue affects everyone and when the Constitution does not take sides on it, it belongs to the people. And so with that in mind, I think that would be, it would be a new road that we would have to chart if that came up as a religious liberty issue. But I think that we would look to the court to navigate those waters.
There's a question for you both, and that is, what kinds of provision other than abortion would you like to see to better support women in the kinds of situations that Michelle described and has written about?
Where do I start? I could think of probably more than 100 off the top of my head. There are racial disparities, extreme racial disparities in pregnancy, childbirth, motherhood, parenting, and we must, as a nation, address all of those. We need to ensure equality in healthcare. We need to ensure that that our doctors are listening to BIPOC women and persons generally. We need to ensure that that all Americans have access to the care and the resources that they need, whether we're talking about legal resources to vindicate their rights in the workplace, or food resources and appropriate food availability, or I mean, I can go on and on, but that's hard work that must be done, no matter what the law on abortion is. That's something that that I'm deeply committed to. In fact, AUL, we filed a brief in Young v. UPS to fight for workplace equality for pregnant women, and we have been actively involved in working towards equal rights on a number of different fronts, from fertilization and through the life spectrum.
So just briefly, for my part, when it first looked, there was some point in the litigation of Dobbs when maybe it was some of the briefs being filed, and it made it clear that Mississippi and amici were going for full reversal of Casey and Roe, or it might have been also in connection with SB 8, that a lot of commentators on Twitter and elsewhere said, well, look, if we're really going to do this, if we're going to regulate abortion so severely, and these were pro-choice commentators, then are you really willing to, for example, tighten the demands on men who are the fathers of the children? Are you ready and willing to create all these further restrictions on whether it's the man or the broader society in terms of a strong social safety net to help lighten the demands on the woman, not completely, but to some serious extent? And a lot of the response among the pro-life commentators and movement leaders was, yes, absolutely, exactly. So in fact, that we don't just think we'll grudgingly grant that as a deal for overcoming abortion, but that we think those are just and required in any case. So there may be some significant common ground. A lot of pro-life people vote conservative mainly because of the life issue, and they're not libertarian more generally, and so they pretty readily support a broad and deep kind of social safety net and other kinds of provisions. So I think that could be one area of common ground in the states where abortion regulations do expand.
Thank you. So this is another question from the audience, but I think I'm going to tweak it a little and ask you both what federal statutory rights for abortion could look like, or federal legislation that undercuts state constitutional protection for abortion rights in a post-Dobbs world. So the question was really getting at, could abortion be made illegal by federal law? But I'm interested in the kind of broader question of how, in the absence of constitutional rights to abortion, or a different standard for constitutional abortion rights under Dobbs, what could federal legislation do for and against abortion?
So I think that's a really interesting question. Justice Kavanaugh at one point in the argument said that the Constitution is strictly neutral on abortion, but at one other point at least, said actually maybe Congress could regulate. Maybe this is for the federal legislatures. It's just not for judges either way. On that point, I think you could make a reasonable argument for Congress taking action in either direction. So you could say that certainly under current Commerce Clause doctrine, there would be more than ample room, I think, for Congress to say, we're just going to pass a law preempting all state abortion bans. I think there's at least some argument in the other direction. So under Section 5 of the 14th Amendment, so first of all, the Commerce Clause, if the Commerce Clause creates the power to regulate abortion at all, that's 1 point in favor of federal power. Against that, you might say, well, traditionally, health regulations, regulations of medical care in general have been a traditional area of state sovereignty. So there's a contrary argument to that, to be sure. Under Section 5 of the 14th Amendment, you could also imagine an argument going either direction. So you could say, look, maybe the courts have not interpreted the Equal Protection Clause or the Due Process Clause to require abortion access, but Congress is empowered under Section 5 to give effect to its own understanding of those. Now, there's a current case, City of Bernie versus Flores, that says that where the Supreme Court said, no, Congress has to stick to our conception of what those rights cover and can only pass legislation that's kind of prophylactic, that sort of can be justified as congruent and proportional to promote the rights as we understand them. But it's not clear to me that the current court would stick with that. I don't know. It divides legal conservatives, so it's hard to say for sure. And if it did say, well, actually, yeah, we don't think that judges are empowered to read the 14th Amendment to require abortion access, but we think there's enough play in the joints that Congress could do that, then you can see Congress legislating in either direction to protect its conception of equal protection for the unborn or its conception of equal protection and due process for women.
I would just add to that along with all of those potential paths that Congress could take, the executive branch as well could use the executive power to direct at least the administration to follow either policies that would protect life or that would advance the right to abortion. In any of those cases, as that original question asked, will the Supreme Court ultimately hold that a right to abortion, a state right to abortion, violates if the Constitution has a right to life, or if the Congress passes a law that would advance a right to life? I think we're a very long way from that, and I wouldn't expect that that would come up. At least in the near term. There are many aspects of this issue that would have to be fleshed out very thoroughly first. And as we saw even in oral argument last week, we're just really at the beginning point of that.
And I'd mentioned that the Women's Health Protection Act has passed the House and is before the Senate, and also the regulation of medication abortion touched on in the questions. Well, that could look very different on the federal level. As our audience members might know, the FDA is poised to rethink how medication abortion is being regulated on December 16th. So with that, I want to thank our panelists. I want to thank Mary Michelle who had to jump off, but Catherine and Sherif as well. I want to thank Petrie-Flom. I want to thank Professor Cohen, and I want to thank Radcliffe for their support of this event. Thank you all for joining us. It's been a pleasure.